So, look, good morning, everyone. Thank you all for making the time this morning, and welcome to our final session of the Future CPO series in 2023. Not quite sure where the year has gone and how we're somehow now counting down the weeks to Christmas, but here we are. So, look, for those who haven't been a part of it, the Future CPO Network has been a 6-part series covering key topics in order to help aspiring chief people officers prepare for that #1 job when it arrives. This is as I say, the final part of the series, and we've picked a topic which seems to just consistently come back around this year, which is I guess a topic at hand for many HR leaders and an important one to tackle. For that reason, we decided to open out this session to the wider HR community so that more people can benefit from it. Hence why there's more people on the session today. So look, I guess from us, we're 3 years into the inception of the HR practice. Next year will be an exciting one as we plan to spin out from Dartmouth and create our own specialist HR brand within the market. I guess at this point, it's important to say that what will remain consistent is our approach to our network and our commitment to providing value add beyond just finding people great roles and filling mandates for clients. So we're currently in discussions internally about how we approach networking next year, what we want to offer to the HR market and community. So if you'd like to be included in events and networking series such as this, please do reach out. If you've got any specific ideas or any feedback from things that we've run previously, please do get in touch with me directly. I'd love to hear from you. Today, I'm delighted to welcome Emmanuelle and Robert from Kingsley Napley. They are immigration and employment law specialists, and they've come to talk to us today about the very prescient problem that HR leaders are dealing with, which is remote working policy, and actually more specifically, those requests that come from abroad, which add that layer of complexity. HR leaders that we speak to regularly are often getting stuck on this topic. It's so complex. There isn't any specific case law to speak of. So it would be really helpful for Emmanuelle and Robert to talk about their experience so far, and to give us some practical guidance in how to handle and how to deal with these issues. The intention for today is for it to be a practical session. So Emmanuelle and Robert will share some slides. They'll talk us through the topic at large, but there will be opportunities for you to jump in and ask questions. I have opened up the chat box, so feel free to type into that, or at the relevant points jump in with questions, and hopefully we'll have some time at the end actually for some group discussion for you guys to share issues, problems that you've dealt with, and obviously to ask Emmanuelle and Robert further questions from there. So thank you all for jumping online this morning, and I'm now delighted to hand over to both Emmanuelle and Robert, who will take it from here.
Thank you, Stephen. So, and thank you all for being with us wherever you may be working this week. We have set this talk to be an introduction to a wider discussion, and if you have questions, as Stephen just said, or you can contribute practical examples of what has worked or not worked in your organization, there will be time at the end to share these experiences. So looking at the agenda, Robert, I thought that I would recap the headline issues faced by employers to allow remote working from abroad, touch on employment and immigration law considerations, and then look at your procedures and policies to reply to requests. And we can also touch on flexible working requests. And then we can hopefully have time for questions and a roundtable as well. So Next slide. In the post-COVID world, probably the biggest change that employers have had to adapt to is remote working, hybrid working, and as an additional complication, remote working from abroad. So that is why you're here this morning. Employees have plainly cottoned on to the fact that if they can work remotely at home, they can do so pretty effectively anywhere in the world, and not just here in the UK. So these are the immediate issues that will need to be dealt with when dealing with a request. So we're only going to look at it from an employment and immigration point of view. I'll touch briefly on the whole, on the rest of the issues as well, because they impact on how we deal with the requests. But only touch on them, and obviously specialist advice, as you all know, needs to be sought for quite a lot of these issues to deal with them. So next slide. I thought I would outline the question that is, of course, essential to understanding the beast. How long does the employee want to work remotely from abroad for? And broadly speaking, when contemplating of overseas employment, there are three main options. Temporary overseas work, remote work, which is what we're talking about, international secondment, and permanent relocation. They all come with their own issues. But what is the difference really between overseas remote work and an international secondment? The difference is that in overseas remote work, the employee is not sent or posted to an entity established overseas. So the intention really is that nothing changes except the employee's location. Sounds easy enough, but because employment laws are territorial in nature, the fact that the employee's location changes is not as straightforward from a legal point of view as from a technological point of view. And that goes with immigration, obviously, because immigration laws are devised to protect each country's territory. So although an overseas remote work arrangement may appear the most straightforward due to its apparent relative simplicity and short-term nature, it may not be appropriate in a particular case. And depending on the circumstances, it may be more appropriate for the employee to be employed by a company in the overseas territory and to be fully integrated into that business if you have subsidiaries, and the posting or working from abroad is for a little while. How long is the question? So next slide. So what are these headline issues employers need to be aware of in relation to remote working outside the UK? First is the fact that local employment law may trump UK employment law in terms of various entitlements, such as annual leave, sick pay, dismissal rights in particular. And before you agree to any proposal that an employee works abroad, that is therefore something that you need to check with a local lawyer, possibly, again, depending on how long the working abroad for is. Secondly, it's terribly easy to informally agree to such an arrangement, but it is preferable to document any agreement in writing. You may want to include, for example, and if applicable, any appropriate timescales where you want the arrangement to be for a limited period of time. You can then realize both sides' expectations and evidence any such arrangements should there come to be a dispute in the future. Thirdly, you should check to see whether there are any local company law obligations which may require you to set up a local office in order to operate in the relevant jurisdiction. Again, that is the conundrum of the permanent establishment, which our corporate colleagues advise on. And that is because a permanent establishment will be created in circumstances where a person acting for the company has and habitually exercises in that country authority to conclude contracts in the company's name. And this is all set out in the OECD Model Tax Convention. However, if the employee in question does not have authority to conclude contracts on the business's behalf, the OECD definition is currently going through a process of consultation. And so even in this circumstance, the definition may be expanded to include employees with less control and that carry out any function for the business, not just functions which involve the conclusion of contracts. So businesses that don't want corporation tax liabilities will need to take steps to reduce the risk of employee activities establishing permanency. And that would include ensuring that the employee's office is not the employer's and the employee cannot conclude contracts on behalf of the business. Another sort of related issue you might, or solution you might have thought of in this context is that of employer of record. And we have seen an increase in consideration of this option. So employers of record in effect act as the legal employer on the ground, and then they take care of any local payroll requirements and can advise on and provide any benefits, including mandatory benefits in the country concerned. This solution, however, is not without risks. You know, how the relationship with the employer of record is set up is important, and the contract there needs to be carefully looked at. But perhaps some of you have such experience and can share it with us after our presentation. So again, it's not, this can be complicated, and will again depend on the length of the posting. On the practical side, I thought a little light point. You should think about how you may be insured should the employee meet with an accident or fall ill while they're based abroad. So you know, ring your broker. Then there are tax implications, and you will need to know what are going to be the tax arrangements once the employee begins to be based away from the UK. Is he going to be paid PAYE, NICs, etc.? Again, tax advice needs to be taken. And then there are the potential data protection considerations and, of course, immigration considerations. And Robert will deal with the immigration considerations shortly. So next slide. That was a quick whistle tour of the headline considerations. In terms of the employment law issues, if an employee is working abroad on a temporary basis and only for a short period, their employment will arguably still have a greater connection with the home country and the UK, and the employment laws of the home country will be more, hopefully, applicable than those with the host countries. If this is the case, the employee is likely to continue to benefit from the home country's statutory employment rights. So, yeah, but in the UK, you know, employment tribunals are actually quite reluctant to assert their jurisdiction over when an employee starts being based abroad for a longer period of time. So we have a whole load of case law on jurisdiction there, and the real crucial nugget is how great is the connection with the home country. That is why you probably all have policies which for overseas working, which limit the length of time that the employee is allowed to go to sometimes, and generally it seems to be 2 weeks or 4 weeks a year. But having said all that, there are other countries which are not as shy of asserting their jurisdiction and in fact, or the jurisdiction of their employment tribunals, and are much more protective of employment rights for employees. So that's the difficulty, because you might end up as the employer with the employee having rights in the UK and in the host country. So it is important to sort of have an idea really of how the host country will treat the overseas working, even if it is on a temporary basis, even if it's on a very temporary basis. and that's also because you might be in a situation where you make redundancies, for example, and the employee is actually posted in France for 3 months. And what will happen then? Will they be able to invoke the protective laws, French laws, in relation to redundancy consultation procedures, for example? So this gives us potentially headaches as employment lawyers. I've put a point as well about the Posted Workers Directive, because you may have thought that that was no longer relevant as we have left the EU. But the Posted Workers Directive was amended and extended in July 2020, widening the definition of posted worker to reduce the gap between posted workers and local workers in the context of the terms and conditions for their employment. And that is obviously a sort of internal EU issue, that some countries in the EU have lower minimum wage levels, for example, and other countries don't want unfair competition from their employers coming to work here, or not here, but in their country. So, but the under the Posted Workers Directive and in implementing that Posted Workers Directives, member states treat individuals posted from non-EU territories as posted workers as well, often. So the Posted Workers Directive entitled any employee working in the member state, including those only temporarily working overseas remotely, to benefit from all local employment laws rather than just the minimum requirements protected under the old Posted Workers Directives, the salaries, hours, holidays. That's how often it's been implemented. And the other sort of less known issue, but nevertheless potentially difficult and costly, is the requirement under the new Posted Workers Directive to complete a registration for every posted worker in the host country. Just that sounds really very comprehensive as a piece of EU legislation. The definition of a posted worker is a person who is sent by an employer in one EU member state to another EU member state to provide services on a temporary basis. So exactly what we've just been looking at. However, attending business meetings, trade fairs, and conferences are excluded from the directive. So that gives a little bit of scope for arguing that it doesn't apply. But yeah, you may have guessed that I'm French, and a note of warning: what is considered to be a posted worker in France is narrower than in the rest of the EU. This means that a larger number of workers posted to France will not be considered as posted workers in the light of this directive. So that's that's something that can be thought about. However, where France is pretty draconian in its application of the directive is in that registration process. So I recently had a case where a British company was providing catering at the 24 hours of the Mans race, les 24 heures du Mans, and it had come with a crew of 20 for 2 weeks. And there they failed to register their employees with the Inspection du Travail. And although we managed to reduce the fine imposed by the French authorities on the basis that the conditions they employed their workers under met mandatory requirements of French employment law, it remained a significant penalty for what was a relatively short contract. So yeah, that's something to bear in mind of, although I think I haven't, even if you look, and I have some contacts at big accountancy firms where they are more worried about the application of the Posted Workers Directive and all the requirements if you send an employee abroad for a day. to work from their second home. I think they've taken the view that that would, I guess, probably be under the radar, and there's pros and cons in doing that, or not allowing it, being overcautious and not being employee friendly. So even say KPMG allows it. So I think it is good to know in the background. It's good to know if you're going to send people for 3 months or for a little while, but it doesn't necessarily mean that you have to ban all overseas remote working on this basis. So next slide. Yeah, that's more practical considerations, which you're probably all used to working with. How, thinking about the reporting lines, the equipment, working hours. How is it going to work in practice? I'm not going to look through that too much because we're already a bit conscious of time. So we're going to go to the next slide. And that's health and safety, which is again probably not the most fun topic, but I just thought it was important to have a slide on it because you are used to it in applying for your hybrid remote working policy. And obviously it also applies when the employee is working abroad. So every employer has a duty to take reasonable care of the health and safety of their employees, and it's also an implied term of the employment contract. So this slide and the next slide with the relevant legislation to consider are something we can come back to if there's some interest, but it's just to flag it as an issue. And on this, I will hand over to Robert, who will take you through the immigration law considerations.
Thank you. Yeah. So I'm going to briefly touch on, or rather flag up, that there's immigration issues pretty much for everyone if they're working in a country that's not their country of nationality or they don't have permanent residence. So if you have your British citizen employees and they say, I want to go work in France, since Brexit, our passports are significantly diminished in value. And unfortunately, we don't have a free movement. We don't have a right to work in the EU. And you have to think of, well, are there immigration issues by having someone posted or rather just sent to work overseas? So the starting point, or what's a prudent idea, is to look at the rules for each, for the country that the individual wishes to work in, to see will they be allowed to do their planned activities as a visitor, for example, without getting a visa, if they can. And if they can't, they need a visa. You think, well, what immigration options are there? So some countries have sort of been quite proactive and in times of COVID introduced digital nomad visas. So Estonia, for example, and Finland, where if you were coming to work remotely, you could get immigration permission to do that. But a lot of countries haven't introduced such a scheme. The UK hasn't. So you have to just look carefully and think, can they get immigration permission? And if they can, how quickly can you get this sorted? And what are the costs? A big part of countries' approach to deter migration is to make it very expensive. To get a work visa, bureaucratically, it's very painful in a lot of countries. And it's a bit of a battle. So a lot of employers might think, well, you can't be bothered to engage with that, and might use that as a reason to sort of decline any request to work overseas. There's risks around immigration non-compliance for the employee, obviously, if they're working in a country, and if they breach immigration rules and they're found out, but they could be banned, for example, they could be deported, and so on and so on. But obviously, I mean, less of a likely scenario, but there are potentially risks for the employer, for the company, more likely perhaps reputational risks, especially if it doesn't have a presence in that country. But nevertheless, it's a bit embarrassing when your employees get refused entry at the border or they get kicked out of the country for working illegally. So it's just best avoided. If you have employees who are on visas in the UK, there's another added consideration that you have to give weight to. in that they need to be living in the UK to get to settlement, so indefinite leave to remain, like permanent residence. And if they exceed absences over 180 days in any 12-month period, they'll generally break what's termed the continuity of their residence, and they won't be eligible for indefinite leave to remain, so settlement, after they've completed 5 years in the UK. Getting a visa, as I said, is very expensive, particularly in the UK. And if someone exceeds their absences and has to extend their visa, that's obviously quite a costly process for a business to go through. And if you have skilled workers, those with visas, it's sort of an added point just to sort of bear in mind how long can they spend outside the UK without running into difficulties when they come to apply for when they come to be eligible potentially to apply for indefinite leave to remain. There is some sort of discretion with UKVI if there's sort of compassionate and compelling circumstances, but relying on discretion is always a bit of a risk because you don't really know what the outcome will be. But best to sort of manage down those absences for sponsored workers. So that's a bit about people going overseas. To talk about people coming here. So you might have overseas employees who say, I want to come and work remotely in the UK for a bit. And the UK immigration system isn't really geared towards that, unfortunately. It does have some provisions for it, but not a great deal. We have a list of permitted activity. I mean, I think the starting point is visitors can't work in the UK. You can't be paid from a UK source. You can't work in the UK. But they can do what are termed permitted activities, which aren't considered to constitute work. So it's like attending meetings, collecting information for their overseas employment, visiting sites and things like this. So if you can sort of limit what activities your overseas employees want to do in the UK, you could potentially let them come in as visitors, as long as they fall within the permitted activities. As I mentioned earlier, there's no digital nomad visa. So you can't come to the UK to live and work long-term remote and to work remotely. We just don't have provisions for it, unfortunately. Under the visitor guidance for UKVI's caseworkers, so this is like the rules or the instructions that the UK immigration authorities follow rather when they're sort of considering applications. You can do some remote working as a visitor, such as responding to emails and answering phone calls, but it can't be your primary purpose for your visit. So, for example, you're coming to the UK to attend meetings, or you're coming to have a holiday, and you get some phone calls and you do some emails. That's fair game. You can do that. But if you were coming to the UK just for an extended period, purely because you want to live and work in the UK and don't have a work permission, that's not permitted. You're not allowed to do that as a visitor. There's also another thing that catches people out is that you can't be a de facto resident in the UK through frequent and successive visits. So you might have an employee who sort of spends a long time in the UK and regularly visits. Although you can come to the UK for up to 6 months as a visitor, if you go beyond, well, I mean, obviously go beyond that, you're an overstayer, but if you're regularly traveling into the UK, it's possible that immigration officials will consider that you're not a visitor, that you're probably living in the UK, especially if you spend 2 or 3 month periods in the UK, and at the border eventually, you'll probably get questions and they'll delve in to say, well, why are you spending so much time here? Where's your income from, and what are you doing in the UK? And obviously, if that happens, there's risks and worries about people being refused entry at the border as well. Okay, so that's a race through of the immigration issues. So I'll pass back to Emmanuelle. That's okay. I think you're on mute, Emmanuelle. Oh, Emmanuelle is still on mute.
Apologies, I had issues with my mouse. So yes, in terms of procedures and policies to reply to requests, it is obviously a good idea to have a policy that helps you sort of deal with requests consistently. We'll touch on all these points in each slide. So we can go to the next slide, which deals with advance approval, because that's in theory pretty easy and straightforward to put in place, and I'm sure you all have it. But it's not that easy to actually consistently force through as a policy. I mean, it is obviously possible and should happen. But you don't necessarily know if employees just say at the last minute, oh, well, actually, yes, I was going to go on holiday for a week, but in fact I've got a meeting and now I'm going to work during that day. And you know, should they let you know? How will they let you know? I think to sort of embed this requirement is something as HR practitioners that you probably have had to work hard on, but it is really worth trying to get this to happen, because it's the only way that you will know what's happening with your employees when they go abroad. If they tag a day or so of working along their holiday period. So yeah, that's that's important. And it's because you may require sort of tax considerations, immigration considerations, etc. on that for that one day that the employee says they will work from abroad. There's another issue is about job adverts. So sometimes there have been adverts that have led to a recruitment that employees that isn't satisfactory, because employees think that they can easily work from remotely from abroad, and in fact there's a policy, or they're not able to do so because of the criteria chosen by the employer to apply the policy. So just bear in mind that job adverts can't be too widely drafted in that respect. And that really is in the next slide, because of what we try to do, which is to have consistent and fair treatment of all requests to work from abroad. So an inconsistent approach to dealing with requests for overseas remote work may result in complaints of discrimination. Again, we don't have any case law on that, but we could see that happen. And for example, an employer should not adopt a blanket approach of only allowing employees from certain countries to work remotely abroad, or to work in particular locations but not others. So that should, you know, you do have to be a bit careful the way you draft the policy. But some rules may be inevitable, and also, an employer may be able to objectively justify certain limitations and restrictions and avoid claims of indirect discrimination. That is, where an employer applies a blanket rule that on the face of it appears fair, but disproportionately impacts employees with protected characteristics such as race, age, or maternity status. So, for example, saying you know, only French employees are allowed to work from France. You couldn't say that, but you could say that only employees who have a passport allowing them to work in that country can work in that country. That would be an objective criteria, because you then would be able to bypass immigration restrictions to working in that country. You can also, other objective criteria could be an imminent or actual threat of political instability or existing conflict in a country where the employee is thinking of requesting to work from, or countries with laws that are at odds with an employer's core values of respect of equality or non-discrimination laws, that these countries might be banned as such, because it might not be safe for an employee to work from that particular host country. I mean, again, they're not easy issues, and maybe if we have time, we can talk about examples you may have. Where appropriate, however, an employer may also want to take an employee's personal circumstances into account when looking into the request. For example, if an employee lives alone and they somehow need to, that was more applicable during COVID, they need to see their family abroad, maybe that could be taken into consideration. You sort of have to be flexible whilst also being mindful of consistent and fair treatment. So next slide is that we do need to have a policy in place. Next slide again. I just thought briefly to look at the few examples, such as how it can happen. So you might have an employee's wishing, as I said before, to add a day working from home abroad to a long weekend abroad. You could have issues where an employee, say you have a working remotely policy with 10 days a year working abroad, the employees already have taken 6 days. You only have 4 days left, but the employee wants to take an extra week at Christmas. Basically they would only have 4 days to play with, so an extra day would have to be a holiday. So then will they be working, not working? You need to be mindful of that, and in fact that if they want to be abroad, they will have to take it as a holiday. If they want to work or need to work, they might need to stay in the UK. What doesn't constitute maybe a remote working from abroad is also important to state in a policy. So say maybe checking emails on an occasional basis to monitor or respond to emails received whilst on annual leave abroad. You would expect that not to constitute remote working from abroad. So moving on to the next slide, and I thought it was important to touch on flexible working requests, because maybe you think that you can avoid the headache of considering overseas remote requests by having a blanket policy refusing them, but then you may need to think again, as a request could come back by the back door of the flexible working request. So if it is a flexible working request, then it should be handled in accordance with the relevant law and internal flexible working policy you may have in place. And you can look, of course, at the ACAS code to handle flexible working requests. But in broad terms, the current position, and I say the current position because it is supposed to change, was supposed to change this summer, but probably next summer. But at the moment, employees with at least 26 weeks continuous service have the statutory right to make a flexible working request. An employee can only make a statutory request once in any 12-month period. And requests, including any appeals, must be considered and decided upon within 3 months of the request. This period may be extended by agreement with the employee. A request for flexible working must be in writing and include certain information such as the date of the application, the change to working conditions they are seeking, and when they would like the change to come into effect. So it could be a temporary change to work overseas remotely. What effect, if any, the employee thinks the requested change would have on you as the employer, and how, in their opinion, any such effect might be dealt with. A statement that this is a statutory request, and when they have made a previous application for flexible working. The employer should then consider the request, discuss it with the employee, and notify the employee of the outcome. A flexible working request may only be refused on one of the 8 grounds set out in law, the burden of additional costs. And you will see that these grounds don't apply easily to a request for overseas working, particularly if you allow hybrid working. So anyway, these 8 grounds are the burden of additional costs, an inability to reorganize work amongst existing staff, an inability to recruit additional staff, a detrimental impact on quality, detrimental impact on performance, detrimental effect on ability to meet customer demand, insufficient work for the periods the employee proposes to work, a planned structural change to your business. But this regime is expected to change, as I said, and in the next slide I've said the expected changes are to happen in July 2024 to give employers time to prepare, and the changes are that employees will be able to make 2, not 1 flexible working request in a 12-month period. Employers will have to consult with employees before refusing a flexible working request. So even more consultation. And when making a flexible working request, employees will no longer have to explain what effect they think the requested change would have on their employer and how that effect might be dealt with. However, that does not mean that this issue cannot be considered or discussed as part of the consultation process. And then employers will have to make a decision on a flexible working request within 2 months, not 3 months. So there isn't at the moment a provision making the right to request flexible working from day one, although that's been muted, and watch that space for that. Yeah, there's it is slide for thought, I guess. Well, slide for thoughts. Thoughts that you can sort of add to your arsenal of issues to deal with when about considering remote working requests. So this sort of brings us to the roundtable questions. My guess is that overseas temporary working is here to stay and perhaps expand. Technology is there after all to do it. I'm not aware of any specific cases in the courts in the UK or abroad yet, but the main pitfall I see in terms of employment law is the risk of discrimination in the treatment of requests to work remotely from abroad. And to minimize this risk, it is important to implement clear, objective criteria for approving or rejecting any requests. So yeah, I don't know whether, I don't think anybody's put questions in the chat yet. I don't know whether you want to share issues you've had or questions you have on our talk.
Yeah, they haven't, Emmanuelle. So I just invite anybody with any questions just to jump right in. Hopefully we won't talk over each other.
Actually, hi everybody. Thank you very much for the talk today. It's been really, really fascinating. I have a question for Emmanuelle. You mentioned earlier that people coming into the UK can do certain activities, which I think sort of most of us already know. But how is that actually controlled in terms of monitored? Is it just via the border force asking questions when that person enters the country, or is there a more rigorous approach to it?
I think that's a question for Robert.
No, Emmanuelle, you
okay.
have
Thank you.
That's what I would do. I would go and see Robert.
So I mean that's a fair question, Annabelle. You sort of point out a big hole in the hole. How do they know? What on earth do they? What information do they have? You know, and what people are up to in the UK. So I think that's right. Really, it's the main way that they police and control what people are doing in the UK is questioning people at the border. But beyond that, once someone's in the UK, what they're up to and what activities they actually do, it's very difficult for UK border force to know. I mean, that's just how it is. I mean, when they find out about breaches of immigration, or when someone's working illegally in the UK, there's lots of ways that happens, but it's sometimes disgruntled employees telling UKPI or that someone's working illegally or doing something that they can't be doing as a visitor and things like that. But it's difficult for them to know.
Thanks very much.
Okay, I see a question for me in the chat about freelancers. So somebody who's a German national wants to move back to Germany and continue in a freelance capacity. Well, that's a typical issue that you would have, and actually that's where you would need to warn the individual in question that they will need to see in Germany. I mean, he's a German or they are a German national, so that's fine. They can work in Germany. There would be no issue for you. You would change the employment relationship into a freelance consultancy arrangement. That I wouldn't see any issue even from a tax point of view with that either, because it is really about the person then being subject to German law, and I don't think it would impact your. Presumably, you don't have an entity in Germany.
No, we don't.
So you would just terminate his employment contract in the UK, and then rehire under a consultancy agreement. If they do exactly the same thing, as you know, that is an issue in the UK, because they might end up thinking they have employment protection rights in the UK, but as an employee, but as they've moved to Germany, and the UK employment courts would then, employment tribunals would decide that they don't have jurisdiction to look at a claim for employment status, because the person is based in Germany, you will be fine.
Thank you.
I've got a question.
There has been another question in the chat. Is it?
Yeah,
sorry,
Hazel.
Yeah.
So if someone goes abroad on holiday and wants to add a week of work, is that possible or not? Well, there are all these, and wanted to add a week onto that. Yeah, there are all these issues to consider. Are they allowed to work there or not? If they, you could, what I think what we see a lot, and I think what is a safe way to go about this is to put in your working in your policy, or a working abroad policy, that a condition for being allowed to work from abroad under the policy is to have permission to work in that country. So either hold a passport of that country, or being able to demonstrate that you have got that permission. I don't know whether Robert wants to add.
Yeah, no, I mean, it's going to depend on the immigration laws of that country. So Australia, in the example, so you'd have to see, if they're not an Australian national, can they work remotely in that country? And it might well be the case that no, they can't.
So just to clarify, if somebody's going off anywhere in the world but are not a national, we should act with caution, because they probably will be incurring some sort of breach of visa rules. But if they're going back to their homeland, of which they have a passport or a right to work, then it's okay. So they're Australian and going back to Australia and would like to tag on a week. From the immigration point of view, that's visa point of view, that's probably okay.
Yeah, so it depends on I mean, if they're a national of the country, it's invariably going to be okay, but it depends on the nationality laws of the country that they're in, and what nationality they have. Obviously, EU nationals, if they're anywhere in the EU, they have a right to work. And New Zealand nationals, for example, they have a right to work in Australia. So you'd have to be a bit more nuanced about it and look at it and think, well, do they actually have permission to be there and to work, unfortunately.
Yeah. Okay, thank you. Very helpful.
So yeah, and again on the fair treatment and the wording of the policy, you would just say that you would look to see that the employee has permission to work in that country or holds a passport that gives them permission to work in that country.
Great, thank you both.
Questions.
There's a question from Chris regarding the slides. They aren't my slides, so that would be entirely up to Robert and Emmanuelle as to whether we can share them and distribute them to attendees or not.
I'm sure we can.
Yeah, of course you can. Yeah. Just one more question. What would you say are the key reasons for a policy limit, so we can provide clarity? If I can yeah. That's a really good question, and actually your company has got quite a long 20 days is on the longer side, and although that often employees want that, they would want 4 weeks working abroad. I think going back to all the considerations we looked at, the headline issues, often what we hear is employees say, well, you know, the tax situation is that as long as I'm in the UK for 183 days a year, then you know that shouldn't be a consideration. So why not extend the policy to 6 months working abroad? But I think yeah, I think that there are the other considerations, the fact that you acquire the right to be considered under the employment legislation and mandatory rights of the country that you are working in, the longer you're working there for. So I guess by allowing 20 days a year from abroad, you're making sure the employee isn't there for 3 months in a row, for example, which would, you know, give issues, all these headlines issues we talked about, but in terms of permanent establishment potentially, or data protection issues, and if you discount all these, you still have the employment law rights issue, which is why really we employers restrict the length of time that they allow employees to work from abroad.
Can I just ask, do we, for the companies that have these short-term policies, of which mine does, do you recommend assessing every single request, or do you think you can have a policy and people can just use it, or do we have to assess every single request, and should we be recording it? That is what we're currently doing, and it is taking an enormous amount of time, and I'm really questioning the value when we've got, I think in the last 6 months, 93% we approved. So it's just, you know, should we be approving these? You know, should we be checking every one of them, or should we just have the policy and let people do it?
That's a really interesting point, Diane, and I think you could change your policy to say, you know, these are the criteria that we would consider to approve a request for, as long as you don't work for longer than that, as long as you have the permission to work, etc., etc. You exercise your own discretion as to whether or not you can your hybrid working that week is in fact from abroad. I wonder what, and I can't see, you know, I think you can do that. That there would be, yeah, there might be risks, but in that you have less control. But they are forced, if it is for a limited time, I can't really see that you have too many risks. And then maybe you could tie it with a sort of disciplinary policy, that if you in fact haven't fulfilled these criteria as the employee requesting the working from abroad, then that would be a disciplinary issue. So maybe some education around that. And does anybody else want to come in on that as to what they do in their companies?
Yeah, there's another question, Emmanuelle, in the chat, which is related, and it was actually something I was going to bring up. We're seeing a lot of our clients implement this. You can work from abroad for 4 weeks a year, sometimes actually on 2 occasions. So they'll have like a summer shutdown, and you can work from anywhere for a month, for example. So how does that work in practice? Should employers be wary of offering such things? Because I think Nicola in the chat has referenced something similar.
Well, yes, in the sense that if you say you can work anywhere in the world, you just have to set out the conditions for remote working so that you don't and the clear criteria for immigration, for tax, for what you're allowed to do, not allowed to do, the data protection issues, etc. But it is doable. Obviously, people are doing it, and for good reasons. That is what employers want to do. So I think again we go back to this policy, and to have a thought on a real thought on how it's working in practice, what you need to do, and then draft criteria that are as objective as possible, potentially applicable without the need to make a request to HR. It sounds like that could be the way forward to dealing with what is happening. Really, is there to stay.
Yeah, I was going to add as well about the right to work implications and issues. So Nicola, I think a lot of companies just don't bother to engage with it. I think that's, and they might think, well, the risk for the company is quite low if our employees are working and breaching immigration laws of another country. Maybe they just shrug their shoulders and let it slide. I think that's probably what happens in a lot of instances. Or the business might say that it's on the employee to tell us, to reassure us that they do have permission to work in that country, and not to delve into it in great detail, because obviously reading the immigration laws of Kenya or somewhere are probably a bit hard going and inaccessible. So yeah, it's probably just missed a lot.
That makes sense. Thank you.
Okay.
Yeah, the risk-based approach. I think that's right. Why is it that we limit to 2 to 4 weeks a year? I think it is a way. It could be many things. It could be management as well. Do you how remote do you want your employees to be? I think if we are talking hybrid working, then we don't want employees just to be away for too long.
Okay, I think everyone's abandoning us now. This is time.
Yeah. It looked that way, and thankfully our fire alarm just managed to finish whilst you guys were still talking. So I've saved you from that pain. But thank you both. It's been really, really helpful and really insightful, and I think everybody's been commenting as such within the chat group. So if you're happy to share the slides, I can then distribute to all of the guests today, and also to those that couldn't make it. I'll also provide them with your contact details, so if they do want to reach out to you directly with any specific questions or follow-ups, they can do so. So again, thank you so much, both of you, for your time and your input today. It's been super helpful.
Thank you for listening.
Cool. All right, guys, have a good day.
Thanks, Robert. Thanks, Emmanuelle. Have a good day, everyone.